More than 2 hours of oral arguments at the United States Supreme Court. History will record it as Case 20719, Donald Trump versus Norma Anderson. Norma Anderson, a Colorado resident, a Republican, who asked the Secretary of State to see whether or not former President Trump should be excluded from that state ballot, having committed, from her point of view, insurrectionist acts on January 6, 2021. The arguments before the Supreme Court were vigorous. Many different parts of the Constitution were examined. I want to bring in former President Trump attorney Tim Parlatore. He spent over a year working on former President Trump's several legal challenges. Most of his work was on the investigatory side, dealing with the classified documents case and the January 6 case with Jack Smith, the special prosecutor. Tim, your overall assessment of what we heard today at the Supreme Court?
I think it was a very interesting argument, and what I think came through is that the justices are looking for a way out of this case where they can, if possible, find complete consensus and issue a unanimous decision on a really very narrow point of law that would dispense of this matter.
On that narrow point of law, did you hear today in that 2 hours of oral arguments some points of law that you think this sometimes disparate Supreme Court of ideologically constructed differences could arrive at a unanimous point of view?
Yes. When Justice Kagan was asking the questions about a single state making a decision that would then bind all other states as to who they can vote for, I think that questioning right there really formed the basis of what I believe the entire opinion is going to be. I wouldn't be surprised if right after this, Chief Justice Roberts goes to Justice Kagan and says, okay, we're going to try and do a unanimous decision based on this narrow issue. To try and I think that they're definitely going to try and avoid a lot of the more contentious issues of, was there an insurrection? What's the definition?
Is the former president an insurrectionist?
Right. I think we didn't hear anything in that oral argument that indicates that they really want to tackle that question. I think that they're really looking for a technical procedural off-ramp that would allow them to say, okay, the Colorado decision can't stand, but it's not on the merits, it's on this procedural thing, and, kick it back.
I want to let our audience know that I'll be getting to Robert Costa, who's with me at the desk here momentarily, and also Jan Crawford, who was in the Supreme Court, will be coming out. But first, I want to go to our CBS News legal contributor, Jessica Levinson. Jessica, your takeaways from this historic gathering and oral arguments before the highest court.
I absolutely agree that we're looking at a Supreme Court that wants an off-ramp. They didn't want this case. They don't want to be here. They don't want to make it look like they're deciding a presidential election. We know what happens to the Supreme Court when it looks like they're doing that. Bush v. Gore, that created a crisis of legitimacy. So what do we have here? I think two main possibilities. And one of them is the idea that Section 3 of the 14th Amendment, that part of the Constitution that we've been talking about, that it doesn't even apply to Trump because he is not an officer, that when he was president, that doesn't kick in Section 3. It doesn't begin. It doesn't apply. And that's where you hear Justice Jackson very forcefully say, weren't we worried about local officials in the South? Weren't we worried about the South rising again? So I saw Justice Jackson really providing a potential off-ramp. And again, I do think the court wants to speak with one voice on this important issue. Another question that we spent a lot of time on is this self-executing, which is just lawyers speak for, does Congress have to act first? And that feeds into these questions of, can a state, in this case Colorado, go it alone? Can a state decide this national issue? As Tim was saying, lots of concerns during the oral arguments about, do we allow a single state to make a big decision for the entire country? If the court were to say, you know what, Congress has to act first, this isn't self-executing, we need a statute first, that also solves that problem. So I think those are the two big off-ramps. Of course, we can talk more in detail.
Jessica, I want to ask you about the presentation of Jason Murray, who was making his first argument before the Supreme Court, and sometimes it got a little hot with some of the justices and their questions, but he came back again and again to the point that under Article 2, states have the ability, constitutionally ascribed, time, manner, and place to run their elections and to decide eligibility. And under that, in addition to the 14th Amendment, Section 3, it was applying its rights under Article 2 and what the 14th Amendment said to reach this conclusion. How did that go over with the court?
My sense is not well. It is the best argument that he could have made, and I think he made it well. The problems, of course, are that I think what we heard the justices latch onto is that there is something different about Section 3 and this disqualification clause than other qualifications for the presidency. And this is where Trump's attorneys, Mitchell, made a great point of saying it's not like age, it's not like citizenship, because this is the type of qualification or disqualification where Congress can vote later. Section 3 talks about it. Congress can vote later and say, we're removing, quote, the disability, meaning by a 2/3 vote, Congress can say, you know what, this person who would have been disqualified, they're not. And so what Mitchell had to respond to is then, why aren't states jumping the gun? Because what we're talking about here is running for office. And what I think Murray had a hard time responding to was, why aren't states acting too quickly? Why is it that we don't have to wait to see if Congress will, in fact, quote, remove this disability? You saw a lot of up and back about timing, about whether or not this part of the Constitution is similar to other qualifications for the presidency. And again, I think that's where he just was not convincing the justices that this insurrection clause is just like an age requirement or a residency requirement or a citizenship requirement.
Jessica Levinson, thank you so much. I want to turn now to our CBS News chief legal correspondent, Jan Crawford. She was inside the courtroom. She is one of the most astute observers, not only of the facts and law, but the conversation, the atmospherics inside the court. Jan, your thoughts as you are emerging from this more than 2-hour historic set of arguments.
Major, it was historic. It was extraordinary. And throughout these 2 hours, I think the conclusion is not whether or not they are going to rule for President Trump and reverse that Colorado Supreme Court decision, but how. And I agree with what I heard Jessica and, of course, Tim saying. They seem to be focusing on two major ways of deciding this opinion. And what's so fascinating about being inside the courtroom is that you can see those 9 justices sitting there on the bench interacting almost with one another through the lawyers as they work through these various possible ways they could decide this case. The bottom line, I think, like I said, President Trump is going to win this case today. But there are legal reasons, strong legal reasons why he has in his favor and why the Colorado Supreme Court, by a vote of 4-3, the only court so far to have ever held that a state could kick a presidential candidate off the ballot for, quote, insurrection. Agree with Jessica. Justice Ketanji Brown Jackson was very interested in focusing on the words and the text and the history of the 14th Amendment, saying it's just not in there. They look at this list. The 14th Amendment provides specific examples of how states can disqualify senators, representatives, electors. It doesn't say president. It doesn't say vice president. But the other justices seem to be coalescing more on a different theme, and that is whether states have this power at all. Justice Kagan, as Jessica mentioned and Tim mentioned, focusing on why does a single state get to decide who the other voters in other states can elect for president? That would be extraordinary, she said. On the flip side, the Trump appointee, Amy Coney Barrett, said this doesn't seem like a state issue at all. The Chief Justice, John Roberts, raised the prospect that other states would follow, but some Republican states may follow, saying, well, this may be an insurrection too, so we can kick a Democratic candidate off the ballot, suggesting that this is going to cause chaos in the states. Now, the attorney for the Colorado voters tried to suggest that, look, this has never happened, this is extraordinary, this is a one-off, but then here comes Justice Alito saying, look, they said that about impeachment. Justice Jackson was impeached. There was 100 years between his impeachment and Bill Clinton. How many have we had since? 3, suggesting if the court rules this today, the same thing's going to happen with this provision, this obscure provision of the 14th Amendment. It's a Pandora's box. I think the justices were very conscious of what this ruling may mean, not only for policy, but again, looking at the law and looking at the words.
And Jan, I want to ask you, as the questions were coming, did you get any sense being inside the courtroom that the justices were surprising themselves, or did you get a sense that the justices had these areas in which they were curious and were, through their curiosity, reinforcing one another?
You know, to start the argument, I was a little, at first, I was kind of like, where's Justice Sotomayor going with this? Or, where are they going with this? And it's always, I have to say it's a caveat, and I've covered up this court for 30 years. You hate to read too much into oral argument, okay? Let's just put that out there. That being said, I do think you could see as the argument progressed, they almost started playing off each other, exploring holes in the argument, exploring the ramifications of what a ruling upholding the Colorado Supreme Court would do. And so, yes, I mean, you definitely saw kind of the justices, and you guys heard it. You listened to the arguments, you could hear them say, well, I want to follow back on, what Justice Kagan was saying, and I want to follow up on what Justice Alito was saying. These aren't Republican appointees and liberal appointees reinforcing each other. This was across ideological lines. And I think that is why this is a moment that the court could really show it is above politics. And that's what we saw in court today. You saw 9 justices, very smart people, appointed by Republican and Democratic presidents, different views on the law, trying to find out what these words of this obscure constitutional provision that has never been used before to kick a president off a ballot, what that means. And so I think that's what you're going to see. Whether or not they're going to get 9-0, whether they're going to come together on the reasoning, we'll have to wait and see. My guess is they probably will.
And Jan, Tim made the observation that he thought it would be the Chief Justice's desire on this matter, with a court so focused on in this question and its ramifications, not only for how states conduct the elections, but the larger 2024 presidential election, to have as close to, if not a unanimous decision as possible. Is that your sense as well?
Oh, there's no question. I mean, Tim is absolutely right about that. And there's just no question. Of course, the Chief Justice, on a matter this highly charged, a presidential election, with a candidate as incendiary as Donald Trump, of course the court would want to speak with one voice, 9-0, liberals and conservatives coming together to say this is what the 14th Amendment means. Section 3 doesn't kick in here at all. States don't have this power, or as Justice Jackson said, perhaps it doesn't apply to presidents. So of course he would prefer that. I think he would want to write this decision as the Chief Justice, and I think they would do it pretty quickly. I mean, if you look back, I covered Bush versus Gore. That was suboptimal, to say the least. That was not a good moment for the Supreme Court. 5-4 decision. No one put their name on it. The conservatives voted 5 to hand the presidency over to George Bush. The liberals would have, sided with Al Gore. Not a great moment. The court's public opinion really took a dip after that. This is a different moment. This is an opportunity for this Supreme Court to come up and say unanimously, which is why I think, of course, they would like to do this, the Chief would like to do this, that the 14th Amendment, Section 3 here, does not allow a state to kick Donald Trump off the ballot, or to allow the state of Texas to kick Joe Biden off the ballot. I think that's what they're hoping to get.
Jan Crawford outside the Supreme Court, thank you so much. Moments ago, former President Trump spoke to reporters at an event at his Florida residence. This just after the Supreme Court arguments were over. We can hear whether former President Trump can be declared ineligible from Colorado's primary ballot. Let's listen to the former president.
It was a beautiful thing to watch in many respects. It's unfortunate that we have to go through a thing like that. I consider it to be more election interference by the Democrats. That's what they're doing. The good news is we're leading virtually every poll. We're leading I don't even know if we have anymore. I'm not sure that we even have a Republican candidate, somebody running, but not making any impact. So as you know, we won Iowa, we won New Hampshire in records, and each one a record. We think we're going to do very well. I'm heading out right now to Nevada for the caucus and the caucuses, and I think we're going to do very well there. All polls indicate we're in the 90s, maybe more than the 90s. We certainly did well in a primary that didn't matter, where they voted very nicely. And we have tremendous support from the people of our country. They hate what's happening at the border. They hate what's happening just generally. We're not a respected country anymore. We're laughed at all over the world. They're laughing at us. And they hate what's happening. They hate seeing it. They love our country. They want it to come back. And we're going to do that. If you think about it.
As former President Trump outside his Mar-a-Lago residence, Robert Costa, Chief Elections and Campaign Correspondent. Robert, not only what the president said, kind of typical, what we would imagine he would say, but your reactions to what happened at the Supreme Court today as well.
What you saw from former President Trump there was effectively a shrug. He's looking at what's happening at the Supreme Court and not believing it's going to have any effect on his run for the Republican presidential nomination. He didn't even name his own opponent, who's still in the race, former Trump ambassador Nikki Haley. And in a sense, this isn't going to have an immediate effect on the Republican race. Based on our reporting at CBS News, our own conversations with voters, they're not paying close attention to every single iteration of a Trump legal challenge. In fact, many of these challenges stoke their own grievances about how they feel about former President Trump. We've seen that in state after state. And he and his campaign advisors believe he will be able to wrap up the Republican nomination.
It strikes me, though, Robert, that there was a chance for the president to talk more broadly to the country, because when you and I were in Iowa and New Hampshire, I encountered Democrats who were uncomfortable, who were queasy about this idea of states taking his name off the ballot. They themselves felt it was a place that, you know, I don't want to see former President Trump reelected. I don't care if the Republicans nominate him, but I'm not comfortable with this. That could have been a moment for the president to speak more broadly about something that I think outside of most loyal Republican Trump voters, even some Democrats are uncomfortable with.
And he's made similar points to that publicly before. The challenge for the Trump campaign, based on some of my conversations with his allies, is that they'd rather be talking about issues like the border and the economy, foreign policy, not about January 6th. Because January 6th, even if it stokes some of the grievances of his supporters, the core and the base of the GOP, it's not the favorite issue of those kind of swing voters in suburban areas around different battlegrounds. But January 6th, because of these cases, not just what's before the Supreme Court today, but the looming trial, possibly led by special counsel Jack Smith, slated to come later this year, will bring these issues front and center once again. We had that in 2022. With the January 6th committee hearings. Now they're revived again. Questions about his conduct, his decisions in and around the January 6th certification of the presidential election. So for the Biden campaign, this is something they believe will remind voters who might be on the fence about President Biden about what they are defining as an extremist movement in this country that was part of what happened on January 6th. So the dividing lines politically are becoming very sharp and very rough. These are rough political waters, even as the legal battles unfold in their own way constitutionally and elsewhere.
Robert Costa mentions rough political waters. I want to bring in CBS News election law contributor David Becker, who is outside the Supreme Court alongside our Jan Crawford. It's been said here, David, that the Supreme Court knows that these are turbulent political waters, wants to navigate them as best it can in concert with the law and the textual understanding of the Constitution. Your impressions of today's arguments?
Yeah, it's very clear that's exactly right. All 9 justices were incredibly engaged in this discussion, all asked questions of all of the lawyers involved. And it seemed like they were all meandering around the same general path to possible final resolution here. There was no discussion of whether or not Trump actually engaged in an insurrection. That was generally just passed over. And where they really seemed to focus, they focused a little bit on whether the presidency is an office of the United States and whether the president is an officer under the United States. But it really focused on whether the states have been authorized by Congress under the Constitution to render these decisions under Section 3. There was a clear concern that that could result in some chaos with different states coming to different conclusions, or even one state, whichever was first to decide it, kind of generally just setting the stage for all of the other states, even though it might have been just one judge in that state that had rendered that ruling. And I think that the justices were clearly concerned about that. I saw that from all 9 justices. What I'd also say, however, is there's another potential chaos that could result from that, which is that barring congressional action, which I think we shouldn't expect in this particular case, that really leaves this for determination by Congress potentially on January 6th. And we could have a lot of discussion and potentially disruption around the idea that Donald Trump, if he won the election in November, he might not be qualified to serve as president of the United States. And so we'll have to see how the Supreme Court ultimately rules on this. I think they are headed towards a fairly consensus ruling on what power states have to resolve this matter, but it could set us up for a big political discussion later on.
David, with your permission, dive a bit more deeply into what you're thinking about January 6, 2025, and this question, and whether you think based on what you heard in the oral arguments this morning, the Supreme Court will not only decide, but try to say something preemptively about those matters that you're referring to?
So I think it's clear the Supreme Court doesn't want to wade into the issue of whether or not Donald Trump engaged in insurrection, the exact language that's used in the 14th Amendment. But if they resolve this in a manner that it appears they're headed, that states have not been authorized by Congress to decide this yet, that Congress has not given them that power, if we also assume that Congress is not likely to give them that power in the next several months, which I think is a fair assumption, then it may be left up to the political process. You can imagine that issue of whether Donald Trump should be qualified to hold the office of the presidency should he win the election in November could be a major, major fight on the floor of Congress on January 6, 2025, with those opposing him, presumably Democrats, bringing up this issue and really fighting it out. There's nothing in the Electoral Count Reform Act that would prevent them from doing that. And I think we should expect that if Donald Trump wins and if that issue of whether or not he engaged in insurrection has not been resolved definitively by the Supreme Court prior to that.
Jan Crawford, not only your thoughts on what David has just shared with us, but also any sense you might have, and I know this is unanswerable, so it's slightly unfair, but I know you have a good instinct about these things, timing of this decision.
Well, I mean, this is a case of first impression. The court has never had this issue before. There's not a lot of case law on it. They're going to want to have a thorough opinion, so we're not going to get this tomorrow. Can we get it in a week or so or 2 weeks? Yeah, I would think so. Super Tuesday is less than a month away, so I don't think they're going to dilly-dally on this. But to pick up on David's point about after the election, I mean, the court, think about the Supreme Court. They look at they believe, all right, I mean, take them for what they say. They believe they're looking at the words of the Constitution, not only on this case, but other cases. You can go back and look at Dobbs, where they overturned Roe versus Wade. If it's not in the Constitution, it's not a matter for the courts. It's for the political branches. So this Supreme Court would be perfectly fine saying, Section 3 of the 14th Amendment does not authorize states to do this. And I agree. I think that's the direction that they're going. That's a matter for Congress to decide. That the Constitution is clear. No one's ever tried to do it. There's a case from 155 years ago where a Chief Justice sitting as a circuit judge suggested the same thing. That is good enough for us because there's nothing else that we have to go on. So, you know, let Congress do it. And that, to me, is very in keeping with the way this court, the majority anyway, believes there should be a balance between the branches.
Thank you so much, Jan Crawford. Jessica Levinson, I want to go back to you because what was so evident to me, and I think everyone else here at the table, is that across the ideological spectrum, there was great curiosity and discussion about consequences of validating, that is to say, the Supreme Court upholding the Colorado Supreme Court judgment to take the former president off the primary ballot. Your impressions of that conversation about future consequences?
I don't think it was a coincidence that what you heard the justices coalescing around is the idea that both the law and the practical consequences were pointing in the same direction. And you heard the justices, again, across the ideological spectrum saying, what happens if we allow a single state, in this case Colorado, to make this decision to say that a federal candidate here, a candidate for the presidency, is not qualified for office? What does that mean for other states? What does that mean for us in terms of just the practicality of this? So I think what you have is a court very worried about what happens outside the courtroom, and they're going to find a way, they're going to find a path to narrowly read Section 3 of the 14th Amendment that we've been talking about all morning to say we're not going to create a scenario where you have this patchwork of one state says one thing, one state says another, with the big caveat that, as David said, we could be waiting for another battle if President Trump once again wins the presidency. We could be waiting for another legal battle. But I think right now what you see is a court saying states don't have the power to do this. That's not how our Constitution is structured, and that's not the ruling that we're going to bless today.
Jessica talks about a possible coming legal battle that might be over insurrection, the definition thereof. Tim Parlatore, I want to ask you, is it important in your mind that that was not a huge focus today, point one? Point two, that there was an impeachment proceeding, the Senate didn't convict, and a grand jury did not indict on the basis of insurrection. What do those three things tell you about this context and where it might be futurely debated on January 6, 2025.
You know, it's one of the interesting things about Section 2383 is that unlike every other statute in the criminal code, it doesn't give a very good definition of insurrection. Yeah, it doesn't give a very good definition of what all the elements of insurrection is. It doesn't surprise me that the court tried to sidestep that issue, because I think one thing that they definitely want to avoid is, you know, coming down with a pronouncement that the Supreme Court said he engaged in insurrection or he didn't, especially when he has a January 6th criminal case pending in the U.S. District Court. So I think it's smart that they, you know, kind of sidestep that. But it does set up, I thought it was interesting, the idea that this could set up an argument on January 6th. And then if Congress is debating on January 6, 2025, whether he engaged in insurrection, what power and precedent does the impeachment not guilty verdict, you know, that acquittal, have on that? You know, can they go back and kind of redo it as a pre-acquittal? It's a very
because that was a
interesting
question
issue.
of incitement.
Right, and also,
and is that a blanket non-conviction, meaning acquittal on all insurrection-related matters?
Well, it's not on all insurrection-related matters. They brought a single count of insurrection, and he was found not guilty on that. The grand jury sitting in D.C., you know, considered all these things and chose to only charge, you know, certain crimes, which was not insurrection. Right. And in fact, the grand juries in D.C., several grand juries in D.C., considered this for a lot of the protesters as well. And, you know, one group they charged with seditious conspiracy, which is the one level below insurrection. So the question of insurrection has been considered by multiple grand juries and by the Senate.
And it's criminal application for people below former President Trump, and not very often applied, or even almost never.
I can't think of a single prosecution, you know, for this.
On that statute.
Correct. Now, I will tell you, the 2383 is a little bit different.
That's the part of the federal code.
Right. The Insurrection Act in the Federal Criminal Code is a little bit different from the 14th Amendment because it kicks out that whole officer thing. Mm-hmm. And it just says anybody who engaged in insurrection is permanently barred. It takes it outside of the idea that Congress can, you know, remove that disability through the 2/3 majority vote. And it's a different and much more expansive application than the 14th Amendment.
Robert, we heard the conversation from David Becker, from Jessica Levinson, and you mentioned a moment ago that for the Biden re-election campaign, whatever comes from this Supreme Court decision, the question of the stakes and the things that may come to this country after Election Day in November loom very large, which means this issue is not going away, even if the former president wins 9-0.
We are clearly in a season of legal war in the sense that former President Trump is battling to stay on the ballot, to fend off all of these charges of insurrection, to face a possible federal trial on his conduct related to that day. This is also a political war. Former President Trump has still not conceded the 2020 election. He's running against an incumbent whose certification day was January 6, 2021. And it's highly unusual to have a former president running again, facing these sorts of issues legally and politically, and to have an incumbent who was directly involved, a rematch with historic stakes legally and politically. And
it is an argument that the former President Trump's campaign likes to make, that because he is popular in the Republican nomination battle, he is effectively politically immunized from all of these questions, constitutional and legal. Hey, he's popular. Republicans want to have him be the nominee. That sort of settles the matter. And that is, for the former president's team and his supporters, at the moment, potent.
And there's nothing in the Constitution, should he ever face prison time, should his federal trial go forward, which is still an if and when at question at this moment, he could still serve as president. He could still be the Republican nominee. What's most interesting to me, based on my reporting, is Republicans across the board at the highest ranks of the party are not ready to push him out of the GOP nomination should these issues continue to cloud his campaign. They're sticking with him almost universally, though there are those critics inside. But so much of the criticism still in 2024 remains private when it's offered, not public.
The momentum is still there and visible. I want to bring in Michigan Secretary of State Jocelyn Benson, who joins us now, also outside the Supreme Court. Madam Secretary, your impressions of what you heard this morning at the High Court.
I was really grateful that the Supreme Court first heard this case and then was very clear throughout the discussion and oral arguments how important it is to provide finality to this matter and to avoid the chaos of having different states making different determinations of ballot access in this case. So my hope is that we'll see a lot of consensus among the justices in their decision, and that decision comes swiftly and soon so that we in the states can get back to the business of running fair and secure elections this year.
Madam Secretary, your state came up in a rhetorical part of the oral arguments. I believe Justice Kagan said, well, what if Colorado does this? What would happen in Michigan? And what would happen in another state? Since your state was invoked in that sense, is there confusion among you and your contemporaries, meaning other secretaries of state, about what to do at this point?
No, since this case emerged and that issue emerged last fall, I was very clear that states do not have the authority to make this call, and that if we did assume that authority of ballot access on the 14th Amendment question here, we would be injecting ourselves into a discussion that actually is better decided by the U.S. Supreme Court, and as the court seemed to hint today, perhaps even by Congress. And so in my view, we have a very clear role in the states, and that is running free and fair elections and providing citizens clarity and certainty that their vote's going to count. These sorts of ambiguous questions about ballot access, when they rise to this level, are best resolved by the U.S. Supreme Court, and I was gratified to see the court really affirm that today in a lot of their discussions, and I'm hopeful that the decision will provide that clear guidance about who has the authority to determine the ballot access question in this case, and in my view, that authority should be squarely with the federal government as opposed to the states.
Madam Secretary, Jocelyn Benson, Democratic Secretary of State of the great state of Michigan, thank you so much for your time. Control room, can we go to Jason Murray or do we go to Jessica Levinson? Please give me some guidance. Jessica Levinson, please weigh in on what you just heard from Secretary of State Benson.
I think she's saying what we heard the Supreme Court saying here, which is I'm not sure that states should be the ones making this determination. We heard, it was just so fascinating, we heard a lot about constitutional structure and these questions of who decides and who has the power, particularly when it comes to the federal government. For anybody who has ever voted before, we know that states do have a lot of power when it comes to our election experience. But what the court was really focusing in on, and I think what we just heard from the Secretary of State, is the idea that maybe on these questions of national importance, where the question is a federal candidate, that you need more guidance than that constitutional provision we've been talking about, Section 3 of the 14th Amendment provides. That you need either a federal statute that says, states, here's when you can act, or you need, which is, we will get some version of it, a Supreme Court ruling that says, states, here is when you can act. Based on everything that we've talked about this morning and all of the really helpful commentary coming out of the oral arguments, I think what we see is the justices, let's remember the head of one of the federal branches of government, are going to end up saying, we can't leave this to the states. Legally, it's wrong. In terms of the practicality, it's wrong in terms of the consequences. And we don't want to leave this up to each individual, either Secretary of State or state Supreme Court, to make these different determinations. There are places in our government where we need to speak with one voice, and this is one of them. What does the Constitution mean? When are you qualified? When are you disqualified as a federal candidate?
Jessica Levinson, thank you so much. Jason Murray, the lawyer for the Colorado voters, just spoke outside of the courthouse. Let's listen.
President Donald Trump engaged in insurrection by inciting a violent mob to attack our Capitol and disenfranchise over 80 million people who voted against him. In doing so, President Trump disqualified himself from holding office. That's not something we are doing to him. That's not something any court is doing to him. That is something he did to himself under our Constitution.
Tim Parlatore, your reaction to what we just heard from Jason Murray.
That's a political speech, not a legal speech.
And that, therefore, will lack clout within the confines of the Supreme Court.
I think so, yeah. I mean, I understand that that's his position, but ultimately, as a lawyer, instead of making political speeches like that, you have to focus on the facts, evidence, and the law, and what the procedures are. And I thought he did a fairly good job in the courtroom, with the arguments that he had. I think that things were against him there, but what he said outside is definitely more political.
I have read some scholars, Tim, who have said, look, the 14th Amendment is clear. The proceedings were delayed. It was a violent riot that delayed them. Had that riot succeeded, a peaceful transfer of power in this country would have been thwarted. By definition, that is something that would fall under the 14th Amendment, Section 3. What would your legal argument or response to that be?
That's something that has to be proven in court. Okay. You can have experts on both sides of the aisle sit there and say whether they think it does or does not apply. But in this country, to actually figure out whether something is or is not an insurrection, you have to bring an indictment, you have to put it in front of a jury, and you have to present the evidence, not hearsay evidence, actual evidence to a jury.
And tested it in the court of law through all due process procedures.
Let the jury decide, and then you respect that process. There is a process. This isn't it.
And what makes the Trump story intriguing legally and politically as a reporter is that this is not about Trump himself as the sitting president at the time marching on the Capitol. He did not march on the Capitol. But the question that's being investigated now that's going to come up in this trial, should it happen, is whether he engaged in a conspiracy to use fraudulent claims about election fraud to then forward what Jack Smith, the special counsel, is arguing was a scheme to hold onto power.
I want to give Jan Crawford, our Supreme Court reporter who's standing outside the Supreme Court, if at all possible. Control room, is that good? The last word? Jan, please.
I think, as we've all said, I mean, this is obviously as a result of these 2+ hours of extraordinary arguments. It's not a question of whether or not President Trump's going to win, but how. And there's two clear grounds that the court could use. One, this we've discussed, that states simply don't have this power under the 14th Amendment to kick a presidential candidate off the ballots, the chaos that would ensue for that. And also, when you think about the purposes, as the Chief Justice said, of the 14th Amendment, the concerns, that was to restrict the power of the states to take people's property and to do all these other things. So it's kind of an upside-down way of looking at that amendment at all. And then, of course, there's the other possible way advanced by Justice Ketanji Brown Jackson that would say that this section doesn't even apply to presidents at all. But either way, it was a good day for former President Trump.
Jan Crawford outside the court with our election law expert David Becker. Our coverage will continue on CBS News Streaming, your local news, and tonight, of course, on the CBS Evening News. This has been a CBS News Special Report. I'm Major Garrett in Washington. Good day.